Hello, I'm Bill Jones. I'm an attorney here in Jacksboro, and I've got the pleasure today of interviewing Judge Shayne Sexton, who recently retired, and after 24 years of serving the 8th Judicial District, including Campbell County, as our criminal court judge. And I'm going to ask him some questions about being judge and let him tell us some things about what that experience is like, and maybe pass down some of that to some of us that are running for judge. So, Judge, I guess I would start off with you were a prosecutor back in the 90s, and when Judge Lee Asbury from Campbell County retired in 1998, you decided to run to replace him. What made you make that decision to run for judge?
You don't wake up one morning and decide you want to be judge. It just happened to open up the year before Judge Asbury announced he was not going to seek re-election. I, in the back of my mind, had rated myself for something in 98, didn't know what it was, just going to let fate take its turn, and it just opened up. So I happened into it. That's the best way to put it. It really wasn't a plan, but it was an open seat, and I just took a shot. But it's been a very rewarding experience, living here, growing up here, and helping people that I never knew I would get to help. So I would strongly recommend, when the opportunities arises, take the opportunity.
Okay, I guess that brings me to my next question. I mean, after 24 years of being judge, being over thousands of cases, lots and lots of jury trials, are you glad you did that in 98? If you could go back to the election in 98, would you choose to run again?
Yes, I would. It was, but you really don't know what you're walking into, but over time, you just develop your processes. We had the opioid, the addiction issue arise early 2000s. That changed the path of the job a little bit. We had to deal primarily with, it became a social aspect as opposed to corrections. We established a recovery court and tried to come up with some solutions to that problem. So I never thought that would occur. We've tried many cases. We've had one of the most active criminal dockets in the state when you break it down into district per capita per judge, and that was very rewarding. I loved participating in trials and watching good attorneys like yourself, knowing how to get cases to a jury. I never thought of the science behind that. I participated in a pilot jury project back in 2002, and we studied how best to put on a trial for the juries. And I learned a lot about people doing that we're not just calling people in and talking over their head. They want to participate, that we've given them trial notebooks now. That was one of the most obvious ways that they became participatory as opposed to just observing. And I say all that because when the jury aspect of the criminal court is involving people who simply just there to do the job. We all are echo chambered. Lawyers, we know how we talk. We all, before the jury gets there, we all understand one another. When the jury gets there, then you've got a whole different set of factors that you're taking in, and that's the public participation part. I really enjoyed that. I will miss that. I missed it through the pandemic because we were mandatorily shut down, and we had to do that. But I missed that, and that's one of the reasons I decided not to run again. I missed that part of it. I may have gotten off your point a little bit, but the most missing the trials and the steadiness of that. I will miss that.
And I guess jury trials is kind of what our whole system is built around. Even if that isn't how most cases go, every case is set that the possibility of a jury trial is at the end of it.
That's right. Without that possibility, we simply can't resolve all the cases that need resolving. It brings a sense of urgency to both sides of a lawsuit, whether it's a civil or criminal. I'm sure you would say your clients sometimes are just not going to plead or resolve their case until they are at the brink of trial.
Right.
The same with the state. Many times the state comes to the brink of a trial and they resolve it. That's not a bad thing. Many times people like to talk plea bargain. We don't want to do away with that entirely. We need that option to resolve cases. Otherwise, we would be in this building 24 hours a day, 7 days a week, trying everything. Speeding tickets, anything with any kind of criminal penalty, you can ask for a jury trial. And we don't want to be in that state. But it's picking and choosing, deciding which cases need to be resolved. And I think we've done a good job at that. I mean, the bar has been a strong participant in that. The lawyers decide generally what we're going to try, and then we just saddle up and do it.
If I'm lucky enough to get elected, that's one thing that I'll miss is jury trials, and I hated that my children never got to come see me try a case. They were going to. We had one a couple months ago, and it got continued the last minute, and that's one thing I'll regret is they didn't see that. I really enjoy trials.
It's an entirely different concept than what we think of in terms of what lawyers think of. So you're right. I hope that at some point they can come down and watch somebody try a case.
Yeah, that'd be great. My next question is about relationship to the bar and I guess the courthouse staff and everything. In my career, I have been very social. Like I've been the Campbell County Bar Association, very involved with statewide Tennessee Association, criminal defense lawyers and different groups, and even the prosecutors, everybody. It seems like being a judge is very isolating. How do you handle your relationship with attorneys and the rest of the legal system as judge?
It can be isolating. By its very nature, it puts you off to the side. But you have to work through that. I mean, it is. We're still people. Judges are persons that have those interpersonal relationship needs, and being friendly is not necessarily unethical. Certainly, being friendly should be expected to everyone. Respectful and treating everyone in a decent fashion. I've been to a point. I think I've tried to be friendly with the bar. I think you tend to feel it when you might be getting a little too close to a case, and I've rarely had that feeling because I've really just, one of the things I do when preparing for cases, I don't prepare. I will come in and try a case without having looked at the file.
Cold,
because I don't want to start drawing boundaries to a case until we get the jury there and that sort of thing. And that, I think that's probably the solution to the lack of isolation. I mean, if I don't look too deep into a case, or if I don't spend too much time with Bill Jones, then I'm not going to have that problem. It is very isolating, and I've had some colleagues that have suffered through that isolation. It just never has bothered me in that sense. I've had some get along with my clerks great. I think the bar, I get along with the bar great. We have a gentle understanding of what we all do, and so with very few exceptions, it's been a good relationship, in my opinion.
I guess another question I have is kind of along those same lines. It is, as an attorney, when I have problems with a case, I have a difficult case, I'll call other attorneys for help, and other attorneys call me for help, and we discuss cases. I've had attorneys bring their cases to my office, and we sit down and go through the whole thing before they have a jury trial. When you're a judge and you run into a difficult problem, you obviously can't call other attorneys. Who do you call for help, or are you able to do that at all?
Early on, I did. I don't so much anymore, and it's not because I know everything. Judges throughout the state, we're not necessarily fungible. For instance, my colleagues in Shelby County, in Memphis, or my Davidson, or whatever county, things run so differently that it's hard to get any bearing from. If I picked up a phone and called my friend in Davidson, probably couldn't help me. I mean, the law speaks for itself, and we go dig in every time. We'll have some evidentiary issues that we talk about, but for the most part, we just learn to solve it right then and make a call. And I'm not saying that that's. I think it has more to do with the independence side that we develop over time. That you just you know that you can't pick up the phone much at all, so you just bite the bullet and make the call. They're there though, and I've had good relationships with bench colleagues throughout the state, and we talk. Usually, when we talk, it's soon after something's happened in court that wasn't funny when it happened, but it was funny the next day, and we'll just tell these war stories and that sort of thing. But it's not
call them and say, "Listen, what happened to me?"
Yeah, I said, "Oh, I got one for you, buddy," and that's something that I think most judges recognize, that when you're trying to maintain order in a case or in a regular court proceeding, and something is a little disorderly, you deal with it. The next day, you're laughing about it. It's just kind of humorous, unless there were some sort of brawl, which hasn't happened. But
we've seen you come close. But
there have been some heated moments, but those would not be funny. But some things are just you can't deny the humor in them. So those are what we share. If I had a problem, though, I've got a list of ladies that I could call and say, "Help me out here," and they would do it.
Were you able to call Judge Lee Asbury?
Yes, he was very kind to me coming in. He made it clear that he was there, but he did not want to guide me through many things, because you have to do it yourself. I mean, his personality is a little different. He came from a defense background. I was a prosecutor. Not that it doesn't make a whole lot of difference when it comes to the law, but how you handle situations might be done a little differently. He was very kind, and was. If I had wanted him more, he would have been there. I used him some, and then I just thought I would again bite the bullet and learn it on my own. Just go. And to be fair, I've made many mistakes over the years when it comes to establishing the processes. But whatever I did and it didn't work, you scrap it and you move on. You figure out what that problem was from my standpoint, and if the solution didn't work, you come to another one. But doubling down on an unworking solution is not the answer I've found. And he would have been. Judge Asbury would have been quick to tell me if he thought I was blowing something up. Fortunately, he didn't have to do that.
That's good.
Yeah.
Well, I guess along those lines, you make decisions every day that affect people's lives, affect their families, sometimes generations of families. How do you deal with, me personally, if I go to a restaurant and order something, as soon as I get it served to me, I'm wishing I ordered something else. How do you deal with regret or second guessing yourself from some big decision that you just made? Maybe regret's not the right word, but definitely second guessing. You're going back and thinking, did I do the right thing? Well,
some decisions are just regretful. You've been around cases with tragic facts, and you don't want to be the one doing that. And even sometimes the law doesn't support what you're thinking as a human being ought to happen. But when it comes to if you're the judge, you're the purveyor of the law, you've got to call it like you see it, like the law says. So in that respect, there are a lot of emotional times where you're thinking, I'm not sure that the law supports how I feel about the case. So you have to run from the field, go to the think, and call it that way. Second guessing, I do that routinely. Now, when you've seen the same problem over and over and over, you don't dwell on second guessing quite so much. But when something new occurs and you've got competing interests, you've got put in the criminal background. Many cases, of course, have victims. On the other side, you've got defendants. Everyone is affected by what we do in the courtroom. You can't pick favorites. You just have to pick what the law is telling you to do, apply it. I'm sure you've seen sentencing hearings and that sort of. That's probably the easiest example. Many times as I'm pronouncing a sentence, I'm going through the analysis that we're required to go through, the factors that are applied, the weights that go to the factors. And I'm doing that, thinking as I'm doing that. And I'm also trying to explain it to the people who happen to be there, who've taken their time to come down and watch what we do in the room. And so that helps me with regret. I feel like if we have regrettable facts, we owe a duty to the people that care about that case to explain why we're deciding something. And I've spent a lot of time trying to do that. So to answer your question, it does away with some of that regret, the second guessing. I still go through that often, and of course everything that I do is potentially appealed. Nobody wants to get reversed. You get reversed every now and then. It's just part of the plan. But you want to get it right, and so the second guessing part usually has less to do with getting it right, because I feel like I've done right. It has more to do with how I handle the people involved, and that personalized part. It's part of one of our jury instructions. The jury can have no prejudice or sympathy. I mean, you're basically pulling all of the emotional fire out of a case when you're the judge. That's your job. Yet you're still human. So there's a side of that that might weigh heavily on second guess, regret, the impact that you're having on people doing your job. It's not always comfortable.
I guess seems like one question just leads to the next. That's a great point. Sentencing hearing is a good example. You often have to make decisions that when you follow the law, that you know for a fact that people in the courtroom are going to be very upset. Sometimes the media's there and they're going to make articles that's going to make the public mad. Facebook comments and Facebook articles and posts. And I've seen cases where people were charged with, very serious crimes, found guilty of lesser included that carry less punishment, but
or even acquitted.
Yes.
Yeah.
Well, the situation I'm thinking of, though, is they'll get lesser included, but the victims or people who are involved in the case still want to see the maximum punishment from the original crime. And if they were facing 15 to 25 years, and now they're just looking at 1 to 2, then no matter what you say next is going to make everyone in the room mad.
Right.
How do you handle that, knowing that when you follow the law, you have no choice, that you're going to get backlash just for doing your job, doing what you have to do?
I try not to expose myself to that second-hand opinion making. I feel very engaged with the people that are in court. I feel like that is the best opportunity that I can explain not only the sentence but how we get there, and they've cared enough to come down. So I think that judges owe a duty on that we have to explain why we make a ruling, and try to do it in such a way that it's understood. Can't always do it, and you can't do away with that emotional scrutiny that you're under. Now the Facebook stuff, what little bit I've been around that, or what I've been told, it usually involves people that aren't here, and I don't know what to do about that. I mean, that's like I said, I feel connected and I feel responsible for the people that come to the courthouse and watch the trial and get through the gritty parts as best they can. Someone that doesn't have any real connection other than just what they heard their neighbors say, I don't know what to do about that.
I remember years ago there was even a case that made national news, and it was a decision that you had made. Do you remember Nancy Grace?
Oh, yeah. Yes.
And that was just a case where you sentence someone directly pursuant to Tennessee
It was a done deal.
guidelines, but they were angry at you for that was the law.
Well, yes, that's a funny story. the reporter got mad at the clerk that morning because they wanted to be taken. That plea was to be taken out of the out of the plea line.
Yeah.
They wanted it done early, wanted it done now, and the clerk said no. I mean, it wasn't even in the room when all that occurred. But yeah, that was a total, what I would call an unreasonable shot. But I lived, nobody died, and we moved on. And I laugh at it now. I wasn't laughing.
Yeah, I remember.
I was a little disturbed about all that. But again, I lived. So
after making difficult decisions. I don't say it's unpopular, but they're just decisions that are very difficult because you have two sides to every case, and when you make a decision, one side or the other sometimes is upset. How do you deal with that in the community? When you go out to eat at a restaurant, when you go to grocery store to buy things, I know you're getting approached by people, seeing people that have been in your court or their families. How do you handle that relationship with the community, knowing what you've done has affected them?
Strange enough, that's only happened a handful of times.
Really?
Maybe I don't get out in this community as much as some, but it's not because I grew up here. I consider this my home, and I'm not going to lock my door, and try to stay out of harm's way like that. I'm going to live my life, but the few times it's happened, I've had some good, reasonable conversations with people, and I don't recall any situations where someone was just not able to get around it. I mean, we'd agree to disagree. You have people that say, "Oh, you should have gotten this." Well, that was out of the range. There was that sentence was impossible given the verdict that the jury returned. So it's not going to happen. And I think people are reasonable if they want if they want to open up, want the judge to open up. I feel responsible to do that. I tell them, going out, limited, but not because of that. It's just the way life is shaken, and I feel very connected to the community. Much of it has to do with our efforts in recovery court. We affect a lot of families, not just people who are charged and in the criminal justice system, but the families are very supportive. They've been kind. Not every case has worked out the way that they wanted to, but they have been willing to listen to a reasonable explanation. So I don't have any qualms about how the community's treated me or my family while I've been on the bench. It's been largely a very responsible and a good experience.
One thing I hate you're retiring, but one thing that's nice about you retiring is I can comment on things that you've done now without seeming like a brown noser, I guess. And one thing you've always done well, I thought, is when you have a difficult decision in court, you always turn to the people it affects and explain to them why the decision, and you always do it before the decision comes out. You turn to them, talk to them directly, and say, this is why I'm doing, this is what I have to follow, this is the whole thing, and then the decision comes out. So it definitely softens the blow, and they seem to understand. Communication just seems to mean a lot.
That is, we were talking, it's just explaining that analysis that I think some people think a judge sentence is based on what they had for breakfast.
Yeah.
Just how how they're in the mood. It's not a mood thing, and you got to tell. It's a judge's responsibility to tell the people affected what they're about to hear. The factors that go into that sentence, and then I usually take a break, come back to the office, and get things tooled up as far as what the sentence is going to be. Then I come back in and try to repeat some of the same things, but that just seems to be the responsible way for a judge to handle a case when it comes to people. Just tell them why. I mean, they just come in there and say, "Bam, here's what we're doing." That's cold, and to think that we have to be cold is not correct. we are people, and we're talking to people, so let's all be as personal as possibly can, and be ethical in the process. So
it causes people to be angry when it's very avoidable.
yes, and that's where you mentioned communication. We have to be skilled communicators on every level. I mentioned the jury trials, how sometimes the judge is the communicator to the jury, because lawyers are doing their thing, they're witnesses and that sort of thing. But the court, the judge, has a responsibility to make sure that the jurors get their case in a nice tight box, and that they go back there and work on it. And that's where I felt more allied with them many times than I would have the bar. But it's on every level: jurors, court staff, lawyers. Everyone has their own little communication styles, and the judge has to try to master all that. You're not going to talk to one person the way that you would talk to another. I'm not suggesting that you should take it to another level. I would never suggest that. You'll know it when you get there. You'll know the how a situation requires you to talk or not talk. Sometimes it's don't talk. Don't say something without having thought about it.
When I first started practicing law, attorney that I first worked for, actually I was still in law school, told me the hardest thing about being a lawyer is knowing when to talk and when to shut up. And all these years later, I find that to be very true. Sometimes, even arguing in front of you, I'm watching your face and thinking, do I keep going, or is this good?
You've said enough, Bill.
Yeah, he's done. I think a lot of them have trouble.
Well, I mean, yeah, I've seen many younger lawyers do that, and I want to tell them, stop. I mean, I really want to pass them a note saying, stop.
Yeah.
You've made your point. If you keep going, you're going to end up in the weeds, and I'm going to have to come get you. And I don't like to interfere with how you try a case or how your opponent would try a case. There's a lot of personal style that goes in it, and it would not be proper for any judge to step in and try to tell lawyers, young or old, how to try the case. We're arbiters. We sit there and we wait our turn. That's we, the judges, and when it's our turn, then we take what we've heard and we meld it into something that we call justice. But I've known judges that like to intervene, and that was never my style. Yeah.
How do you handle? I guess being a judge isn't a magical thing. You're a human being. Human beings have emotions up and down. Sometimes we have arguments with our spouses, our kids do crazy things. Things in life are going on regardless of court. Sometimes you're in a great mood, sometimes you're in a bad mood. But everyone expects you when you walk in and sit down to be completely consistent and calm, and how do you maintain that with your own life going on at the same time? Because at the same time, your family at home doesn't care that court's going on. I mean,
a lot of my friends were married when they were elected, and their spouse just knows them not as the judge, but as that person they were married to. So
right.
They're not going to get the same treatment that you get at a courthouse. I mean, most people in every courthouse I've worked in, the staff was so kind, and they would be solicitous of anything that any judge needs. You'll get treated that way at home. It's just part of it. I'm not. I guess your question.
Are you able to, if something bad happens, you have an argument, or maybe someone hit your car, you're in a horribly bad mood, which just happens to everybody. How do you walk in on the bench? Everybody in the courtroom rises up. You walk in, sit down, and they sit down, and you have to put all that away. And
it happens, and you get better at it as you're on the bench longer. But you got to know when to get up off the bench if you're about to do something silly. If you're about to let that personal strife take over your professional decision making, you got to get off the bench. And I've told some of my colleagues, when we've had these discussions, do that. Just don't say anything else. Don't say anything that you might regret. Say something. Don't say something irresponsible. Get up and leave, and come back when you're ready. I learned, some judges are able to go well into the night. I can't. I've known it. I can start feeling when it's time to adjourn for the day and come back tomorrow, because we're just not always as fresh as we need to be. So you learn over time when to give in and go home, and that took some. There were times when I first started, we had a jury out at 2:30 in the morning. Yeah, it was a homicide, and by the time the jury verdict had come in, it was an attempted homicide. And all of a sudden, we didn't have a dead person anymore. We had an attempt, and that's what happens when you keep people that late. I mean, they're going to compromise, or they're not. After it was like a 4-day trial, and
brought the victim back to life.
Yes, it was. You could say that from the verdict. I mean, all of a sudden, we did not have a homicide. We had an attempted homicide. So it's a.
I've seen you take breaks during. I know one of the most taxing things you've done, because I've sat and watched you do it for years, is probation violations. Because that's where a lot of people end up actually going to prison, and that's a hard thing to do. And I've seen you get halfway, 3/4 of the way through one of those dockets and say, I need a 15-minute break.
I'm doing everybody a favor when I do that. I mean, somebody is about to get it, and I don't. I've heard jokes over the years where defendants, probation violations in particular, will be wondering, what mood's the judge in. I hear the the jail staff talk about it, and that always bothered me, because I wanted a defendant, whomever, I wanted to defend the victim ever, to get the same judge at 4:30 as they had at 9:30.
Right.
Because that's not justice. If where you fall on the docket is the level of justice that you get, that's not justice. And I've had to learn that. I like one of the styles that I've adopted is to keep court going. We rarely take full lunch breaks, and I know it sounds merciless, but the reason I do that is to keep the momentum of the day going, and that's one of my things. I know some judges take the full hour for lunch. That's fine. I don't think there's anything wrong with that. It was a personal idea of mine, but you got to know when to break, and you have to know when to let the parties break. I've seen lawyers that get used to eating at 12 to 1. If you don't let that happen, about 2, they're going to be throwing stuff at each other, and that's not conducive to any good justice. When people are angry, lawyers get mad at one another. We don't want that. Nobody wants that. So I'm conscious of that. I can see if you were getting worn down, I think I could tell, and that's one of those things. Maybe we need to take some time, because if you can't defend your interest if you are in an emotional state, or some sort of just a state of deterioration for the length of the day. But that's one of those, in the back of your mind, you're always thinking, is it too late? Are we going too long?
I know that it seems like we always see something new, no matter how many times I do jury trials, or we do the same thing over again. We had a trial not too long ago where a juror got up in the middle while we were in the middle of trying to start walking off, and we asked what she do, and she goes, I need a break, and you just didn't know what to do, and said, well, I guess this is a good time for a break.
She called that shot, I guess, so we'll just take a break. Yeah, I mean, I always felt like I needed to be considerate to the jurors. I know the lawyers do too, but your job primarily is to get your case made. Mine is to keep the jury engaged, and I've learned that the more days that are involved in a trial, the more risk are involved that the case will not finish. we usually pick what we think to be a fair number of alternates to come in case we lose them. But if a 2 or 3 day case, you can bank on one juror, something happening. Somebody's going to get sick. Somebody's got an issue, the rise of a workplace issue. So, trying to build in those tactics that reduce risk is something that any judge ought to do. Now, for sessions courts, you're not dealing with jurors, but you're dealing with a similar. The public. Whether it's witnesses. We just talked, and I don't know how the juvenile works nearly as much. That's been remote for a long time. I can imagine the docket in a criminal general sessions court runs much the same way as a criminal court docket would, in the sense that the ebb and flow. You'll have, let's say, 50 cases on a day. I'm just making that number up. But you've got the state will have witnesses, the defense is going to have witnesses, police officers are involved, and nobody really wants to be there. Nobody really. So the question is, how do we get to the end of the docket as quickly as possible? And my approach to that was keep everybody in the room, keep working, and finish it. The breaks would. That's where the motivation to finish to end the docket comes in. When we take too long a lunch break, that's when we get in trouble. That was my solution. I don't suggest that to anyone. It fell more into my preference, but I take care of the jurors and keeping them everything moving. I mentioned that pilot program. One of the things that we learned early on, this is all through exit polling from jurors, don't keep them waiting. They do not want to keep them in the hot box in the jury room waiting on us to do work that's happening. Sometimes it just has to happen. It's necessary. But many times the jury, of course, they don't know what we're doing. They think they're wasting their time, and that's been an important part of my thinking over the years, is to keep court moving, keep everyone engaged, and I think you'll have less trouble doing that.
I definitely think in jury trials that I can feel when the jury's getting tired and when they're sick of hearing the same thing over and over again, and if they feel like I'm wasting their time, they're going to punish my client for it. I worry about that a lot.
Potentially, and they just tired. There's human beings too, and once you've made the point, I mean, it's pretty scientific why most sitcoms are 30 minutes long. That's all somebody can take. So we've heard many closing arguments over the years run into the hours, and I'm like, "Oh, you're killing them." I mean, if you can't make that point quick, you really don't know what your point is. And but that's just an example. And most people behave the same. They're self-interest. What they want to get to the end of the day. Most of the jurors that I've come in contact with, more personally after they've served, they like doing it. They don't love doing it, but they're willing to do it as long as they're treated well when they come down. And that's been a lot of the approach I've tried to take, not just with jurors, but with everyone. Get to their case. Let's get it heard. Let's not, obviously waste time. Sometimes we have to slow down, but valuing people's time is a very important part of a judge's life.
All right, I guess the last question I would have is, what advice would you give a new judge? What would you say is the most important thing you would tell a judge who is brand new to the bench?
Be patient in learning your processes. How you might handle something may look very different than the way another judge. It would be part of your personality, part of the things that you value. Just be patient and let that knowledge come on its own. Thinking that you immediately know what to do in every situation it's just impossible. You can't know everything. What I tried to do over the years is plan for 90%. You see 90% of a trial or a day, whatever it was, plan for that, and I can handle the 10% that's unexpected. If you've got everything else ground down tight, and that, of course, that you're not going to be doing that. You know, I wasn't doing that right out the gate. You had to learn the patience, but things tend to slow down for you. And if I were advising a young judge, it would be let that speed take its own. Don't try to run toward it. It'll come, and there'll be times that a judge would just feel the mistakes being made. Don't feel bad about that. This is a lot of, I hate to use the word trial and error, but it is. I mean, there's a lot of shotgun approach when it comes to how a judge would run the docket, run their system. You know, I mentioned early on about the opioids, that collision with what we do in court was startling. I mean, and I know I'm sure you've had the experience with sometimes dealing with impaired people, and how you reason or how you can't reason with some, and that didn't exist before 2002. I mean, we had, you know, there was impairment issues and maybe some addiction, but not to the degree that the opioids brought on, and it was almost a lost group of people that you just couldn't get out. I say that because you can't anticipate that problem, so you just have to let that problem fester and see what the solution is and run with the solution.
You didn't see that coming in '98?
Oh no. I remember the first time I heard the word OxyContin, 2001. A friend of mine that I'd gone to school with had overdosed and died, and I was getting the details from someone else, and OxyContin was the cause, and I had never heard of it. And then this came in a flood, and that was the genesis of the recovery court, and other ways to deal with it. I did not understand treatment. I did not understand rehab. I thought you'd send someone to rehab, they'd come back, they're fine, and that was just me not understanding addiction or impairment or that whole phenomenon. So, like I said, you try to look for the 90%. That's one you can't predict, and you just got to work the problem when it comes to you. But you let it come to you. You can overreact if you don't watch it. I mean, there are things that I have done in the past that were sheer overreaction, and I remember them now. I know them for what they are, and that was just me getting in a hurry. So.
But you learn from that.
You learn.
Sticks with you.
Yes, you pump the brakes when you need to, and don't just let it come to you.
Judge, thank you so much for sitting down with me and answering these questions, and thanks for all your service to Campbell County over the last 24 years, and we really hope you enjoy your retirement.
Thank you. I will. It's been a pleasure sitting with you. I think it's wise on your part just to survey, ask the questions. You may avoid some steps over the years if you're elected, and you won't have to repeat some of the mistakes I made. So.
All right. Thanks a lot.
You're welcome.